Hello and welcome back to our YouTube channel. Well, it is 21st lecture of Indian polity, and today we are going to discuss the state machinery. So, before we'll start our discussion, I would like to take a minute to give the brief introduction about the initiative so that if you are new to our channel, you will get more connected with us. Basically from 2nd June, we had started the initiative by the name Target IAS 2026. Under this initiative, every day we upload two videos. One in the morning session where we discuss your current affairs. We take up the most important news articles, we discuss them, and we show you how they are relevant for your preparation with respect to your prelims exam as well as with respect to your mains exam. So we prepare your current affairs in the first video. And in the second video, which is this video, here we discuss your static syllabus, and we started with Indian polity. As you can see here, it is the 21st lecture of Indian polity, and here we had promised you that by the month of January 2026 we are going to complete your full syllabus. Whatever is required for you to clear the exam, we will cover it here, but here is an exception, that is we are not going to cover your optional subjects. And one more thing, as we are delivering the lectures here, at the same time we are preparing your notes of these subjects which we are delivering here. And once we will complete the syllabus of a particular subject, like we are discussing Indian polity right now, once we will complete the syllabus of Indian polity, the notes of Indian polity would be available. And if you would want to avail the service of our notes, you would just have to mail us, and you will have to pay 200 rupees for the notes. We will definitely send you these notes, and these notes would be very much different from the conventional books which you read, because in these notes will contain every topic would be discussed, and after every discussion there would be the questions related to prelims as well as mains exam which would be discussed there. So if you would want to get the service of these notes, it is up to you. Do mail us and we will definitely send you these notes. And also, if you want to join this initiative, please do subscribe the channel, do share it with your friends, and also please do write in the comments what else should we bring for you guys. Now this is about the initiative which we had started from 2nd June. Now without any delay, let's start with our discussion. Let's start where we left yesterday. Yesterday we completed the union legislature. We discussed every important concept of the union legislature, and from today we are going to discuss the state machinery. Let's try to recap what we discussed with respect to union. With respect to union, we discussed the union executive, we discussed the union legislature, and in union executive we discussed the president, we discussed the vice president, we discussed the PM, we discussed the council of ministers, and we discussed the attorney general for India. And with respect to union legislature, we discussed the president, his role, we discussed the Lok Sabha, and we discussed the Rajya Sabha, and everything whatever is required, we discussed everything, whether it would be with respect to the introduction of the bills, whether it would be with respect to the powers of the Rajya Sabha, whether it would be in relation to the powers of the Lok Sabha, how are members qualified to these houses, what are the different qualifications, how are elections done, everything we discussed. Then we discussed in yesterday's classes different types of motions, we discussed different types of resolution, we discussed the budget session, we discussed everything, and also we discussed the president, vice president, everything. So now today we have to discuss the state machinery. As we know that our country, we have the federal structure. So for the state, the structure is almost same. In the state machinery, we will have the legislative part of the state also, and we will have the executive part of the state. So what contains the executive part? It is the governor, it is the council of ministers, it is the chief minister, it is the council of chief minister, it is the council of minister, and it is the advocate general of that particular state. He would be the advocate general of that state. This will contain the executive part. And in the legislative part, we have the governor, and what we have the legislative state legislative assembly, and for few states we have the legislative council. So this is the structure of the state machinery. With respect to the state machinery, whether it would be the structure of the legislative assembly, It is same as the structure of the Lok Sabha, but there is certain difference would be with respect to the representation. There is a limit with respect to the representation in the legislative assembly, and rest the things would be same. Whether it would be how the bills would be passed, what would be the status with respect to the money bill, how the president would get involved, almost everything would be same. So there is no need to repeat it, but the question is here, there would be slight differences, and those differences we are going to discuss here. So what we are going to discuss, we will discuss how state legislative assembly is different from the Lok Sabha. We'll discuss that, what are the few important points related to that. For example, with respect to legislative assembly, constitution does not specify the strength of the legislative assembly, but it gives us the range. What should be the range, how many MLAs would represent it, and the range given is minimum in the state legislative assembly, minimum it should be 60, and maximum it should be one third of the maximum it should be 500. So this is the range, but there are some certain exceptions. What are those exceptions? For example, with respect to Goa, there is representation is very low. With respect to Sikkim, representation is very low. So that we will discuss there when we will discuss those things, when we will have to discuss article 371. There we will discuss all that stuff. Here what you need to know, the structure, how are these members, what is the qualification of the member to be the part of the state legislative assembly. We know that that is same as the which is same as the Lok Sabha. How they are elected? They are elected by the first past the post system, that we know. It is almost same as that. It is same as what is in the Lok Sabha. So everything would be same, but only difference is the constitution does not describe the maximum strength. Constitution does not describe the strength of the state legislative assembly, but it does give us the range in which range the strength of what should be the strength of the state legislative assembly, and it is between 60 to 500. So now what else should we discuss here? With this, by this small discussion, state legislative assembly is clear. Now everything, how the bills will get introduced, it is almost everything is same as that of the legislative Lok Sabha. Now what we have to discuss in today's discussion? In today's class we will discuss the legislative council, because it is very much different from the Rajya Sabha, and not every state has the legislative council. That we have to discuss. We will discuss the governor, because it is not the governor is different from the president. Governor has certain discretionary powers which he enjoys. We will discuss the mercy powers of the governor. As I told you once, when we were discussing the president, we did not discuss the mercy powers of the president, the judicial powers of the president there. I told you that once we will touch up the governor, there we will discuss that. So we will discuss governor here, his mercy powers. We will discuss the criticism with respect to governor. We will discuss everything. Then we will conclude this state machinery. Everything rest, what I leave here, that would be same as the state legislature, union legislature. So there is no need to repeat it. Wherever there is a union written, replace it with this state. Everything would be same. What are the differences? That we will cover here. So first we discussed the difference with respect to the state legislative assembly. Now let's start with the state legislative council. Let's see what it is. Let me rub it first, then we will start the discussion. When we discussed the Rajya Sabha, and one of the criticism of the Rajya Sabha was that it is not that relevant with respect to the Lok Sabha, and it was said that it is this secondary house of the of the parliament. But that assumption is wrong, because it is believed that the Rajya Sabha is the second house, to show the importance of the Rajya Sabha. With respect to the constitutional amendment bill, that Rajya Sabha is very much relevant. So with respect to the legislative council, it is the secondary house of the state legislature. It is the secondary house of the state legislature. So what does it show? It shows that the inferior quality, or the inferior, it is inferior to what? It is inferior to the legislative assembly of the state. Inferior to legislative assembly of the state. It is very much inferior to the legislative assembly of the state. And also about the state, what is common between legislative council and the Rajya Sabha? Both are permanent houses. Both are permanent houses. It cannot be dissolved. It cannot be dissolved. But can we abolish Rajya Sabha? No. Here the legislative council, it can be abolished. It can be abolished. Legislative council can be abolished. One thing about the Rajya Sabha, that is the federal feature. Is legislative council the federal feature? No, it is not the federal feature. It is something within the states where different representations, different groups are represented. So it can't be the federal feature. So with respect to this, who should decide? This question should come to your mind. Who should decide that the legislative council should be there in a state? It is the state. It is the state who shall decide whether they should have the state legislative council or not. They will pass the resolution for the abolition or for having the state legislative council, and the resolution should be passed by the 2/3 majority present at voting. It should be passed by the 2/3 majority present at voting. And once they will pass this resolution, then this resolution will go to the parliament, and then parliament have the real power to abolish the state legislative council or to add the state legislative council in a particular state. And here the question is, what about this resolution passed by the state legislative assembly? Is it binding on the parliament? The answer is no. This resolution is not binding on the parliament. So it is very much clear. It is the state legislative assembly who would want to have it or not. For that, it is the parliament who will make it. But will parliament make it to any state? No. It is the state who will first pass the resolution, who would recommend the resolution, then parliament will make it for them. So with respect to this, what was the debate in the constituent assembly about the legislative council? Let's have a little discussion over that too. But let me rub it first. What was the debate? When the constituent assembly came in, and there was discussion over it, whether the legislative council should be there or not, as they knew that it is inferior to the legislative assembly. Its role is very much limited. When we will see the maximum it can delay the bills, maximum it can delay the bills is up to 4 months. It is the maximum it can delay the bills. So what is the need for having this? What is the real reason for having it? So it was discussed in the constituent assembly, and finally it was adopted that let's leave it up to the states. If they want it, they will have it. So till now, how many states do have the legislative council? This question can be relevant for your prelims preparation. How many states do have the legislative council? It is 6 states. 6 states have the legislative council. It is Andhra Pradesh, it is Telangana, they have the legislative council. It is Maharashtra, it is Bihar, it is UP and Karnataka. All these states have the legislative council. And before, when Jammu and Kashmir was a state, they also had the legislative council, but right now that is not even a state. That is a different topic. Presently, how many states have the legislative council? It is 6 states who have the legislative council. Now let's discuss about the abolition and the creation of the legislative council. As I told you that it is the state legislative, it is the parliament who has the final authority to abolish or create it. But parliament will not create or abolish on its own. There should be a resolution passed by the state legislative assembly. So let us see what article is responsible for that, which discusses about the abolition and creation of the state legislative assembly. It is Article 169 of the Indian Constitution. It gives power to the parliament to pass an ordinary law. Under Article 69, it gives power to the parliament to pass an ordinary law for creating or abolishing this state legislative council. And this ordinary law, it should not be deemed as the Constitutional Amendment Act. It should not be deemed as the Constitutional Amendment Act. So please remember that. A question may be asked in the prelims exam where they will highlight it that the abolition of the state legislative council, it is considered as the constitutional power of the parliament. No, it is not the constitutional power of the parliament. It won't be considered as the Constitutional Amendment Act. So this statement would be incorrect. So with this, Yes, it is the constitutional power, but it will not be considered as the, it will not be considered as the constitutional amendment act. So let's see, we discussed that how it can be abolished. I told you that if the state legislative assembly, first they have to state legislative assembly, suppose take the example of the, you know of any state which does not have the, which does not have the legislative council. So suppose tomorrow Punjab, they would want to have the legislative council. What they will do, they will pass the resolution by the 2/3 majority present and voting, and this resolution will go to this resolution in which they will request parliament to enact a law. And this resolution, it is not binding, you have to remember that it is not binding on the parliament. Then let's see what is the structure of the legislative council. So abolition and creation, it is same. For the abolition and creation of the legislative council, it is the state legislative assembly who has to pass the resolution by the 2/3 majority of the members present and voting, and this resolution, it is not binding on the parliament. Now let's compare the structure of the, legislative council. Let's try to find out few important facts which are more relevant for your prelims preparation, and let's try to find out those. Now there is we have the legislative council. Suppose legislative council, there would be different members, it will have different strength, and in this legislative council, it is the chairman who would be the presiding officer, and there we have the deputy chairman. So this chairman and deputy chairman, how they are elected? They are both elected by the simple majority. And second, how they are removed? They are removed by the effective majority. So they are elected by the simple majority and removed by the effective majority. How it is different from the Rajya Sabha here? Because in Rajya Sabha, the chairman is the vice president. So in Lok Sabha, chairman is not the vice governor, because there is no post such as vice governor. So both the chairman and the deputy chairman, they are the members of the, they are the part of the legislative council. In the Rajya Sabha, chairman is not the part of the legislative council. So this is the difference. And what would be the composition of the, what would be the strength of the legislative council? Strength, with respect to this, the constitution prescribes the range. And what is the range? Maximum, it should be 40, minimum it should be 40 MLCs they should have, and maximum 1/3 of the state legislative assembly, which is almost 100, 1/3 of the state legislative assembly. So minimum it should have the 40 MLCs, and maximum it should have the 1/3 of the state legislative assembly. So this is the composition, and let's see how they are elected in this legislative council, how the members are elected. There are various ways. In the Rajya Sabha, there are either elected members or the nominated members, but in the legislative council, there are different ways in which they are elected in the legislative council. So let's discuss that. Let's try to find out. Here some are elected by the MLAs, some are elected by the MLAs, and second, some are nominated by the governor, some are nominated by the governor of the state. And how he will nominate them? He will nominate them on following basis. For example, they had done something great in art, literature, science, social science, social services, and cooperative movements. If they have done great in it, then they will elect them. Then they will nominate. Then the governor will nominate them. Then the third would be, some are elected by local bodies, some are elected by local bodies, and some are elected by graduates. And some are elected by teachers. Some are elected by teachers. So a question in your prelims exam may be asked that how about the election of the members of the legislative council. They may say that it is same as the Rajya Sabha. No, it is not same, because in the legislative council it is totally different. In the in the Rajya Sabha there are only two ways. One is nominated and another one is elected. But here that it is very much different. So let's see. A legislative council, it has very unique composition. Now let's see what will happen to different bills when it is passed by the legislative assembly, and what will happen if the legislative council rejects it, with respect to what its powers with respect to different different provisions in the state parliament, we can say maximum. Let's see what will happen to that. For example, here we have the legislative council and here we have the legislative assembly. A bill originating in the legislative council, suppose it passes it, and legislative assembly also passes it, it will go for the governor's assent, and governor will accept it. So no issue with here. Now the legislative council will pass any bill, and let's suppose the legislative assembly will reject it. Then what will happen to the bill? It will be dead, it will stop here. So it shows that the legislative council has the inferior role. Now let's reverse the condition. Suppose the bill is originating in the legislative assembly, and then we have the legislative council. First case, the legislative assembly passes, legislative council passes, goes for the governor's assent and passes. Second, legislative assembly passes, legislative council says no, it will go to the deadlock. And here they have to, in the deadlock, they will have to send it back to the legislative assembly, where it will be either with the amendments or and they will cite the reason. Legislative council will cite the reason why they are not passing it, why they are refusing to pass it. Then it is up to the legislative assembly whether to accept it or not, and once they will pass it again, then it will be deemed as it has been passed. Then the legislative council cannot reject it. Third, legislative assembly passes, and suppose the legislative council does not act on it. How much time they cannot act on it? It is initially for 3 months. After 3 months, it will go back to the legislative assembly, and suppose legislative assembly will pass the same bill, it will go here. Maybe again they will say that they will not react on it. So maximum this time 1 month, then it will go back to the legislative assembly, and there it will be passed again, and finally it will be passed. So maximum they can delay it for the 4 months. Then the fourth is they may amend the bill. It is up to the legislative assembly either to respect them and accept the amendments, or pass the same way, then it would be deemed to be passed. So in this way it shows very much clearly that how the legislative council is inferior to the legislative assembly. So this is how it is inferior. The maximum it can do, legislative council can delay the passage of the bills by maximum 4 months after it will be deemed to have been passed. So maximum it can do, it can delay it up till the 4 months. So this is about the legislative council. These are some important points which you need to know about the legislative council. You may be asked to compare it with the Rajya Sabha. So I guess this is very much clear. Now, is it important to have the legislative council? When we have the members in it, there is different protocol for them. You will have to give different services to them. You will have to have the for their transport services would be given to them. Salaries would be given to them. So is it necessary to have it? And and we look at its role. Maximum it can delay it for 4 months. But one thing is very much clear, that if a person is nominated in the legislative council, he can also become the chief minister. So a person from the legislative council can become the chief minister, and this is the power which it does have. This is the only power which it has. Even the nominated member can be elected as this CM of the state. So now looking at the legislative council, it is functioning, its powers, it does not seem necessary that we should invest money, the state should invest money in having this legislative council, but they still do it so that the representation would be shared all over the state. It is there for the convenience of the governance. They make the legislative council so that there would be proper discussion on the bills. In this case, it is good, rather than it is with respect to its power, it is way much inferior than the legislative assembly, and almost it does have a zero role in with respect to the passage of the bills, because maximum it can delay it for the 4 months. So with this, legislative council is over. Now let's move to the governor of the state. I told you everything else about the state machinery, it is same as with respect to the union machinery, but there are certain changes. For example, with respect to the legislative assembly, what is the strength, that is different, but qualifications, oath, everything, it is same. We have to replace this the union with the state, and president here we have to replace with the governor, and the Attorney General of India, we have to replace it with the Advocate General of India. What are the powers of Attorney General of India? It would be same powers would be shared by the Advocate General of India, but at the state level. Now let's discuss the governor. And this is important post, and it is one of the most controversial posts which we had seen from last few years. Always the post of the governor is always under controversy. Why? There are various reasons for that, and those reasons we will first understand the governor, then we will go to those what are various contradictions, what are various controversies related to governor. First, let's see who appoints him. Who appoints him? It is like the president at the central level who is elected. The governor at the state level, he is not elected, he is appointed. And who appoints him? It is the President of India. President of India will appoint him, will appoint the governor. President of India will appoint the governor of the state. So is it the personal satisfaction of the president? No, it would be the satisfaction of the council of ministers. So they will tell him that particular person should be the governor of a particular state. Now, once the governor is decided, but on what basis? There would be certain recommendations, certain qualifications given by the constitution. These qualifications should a person should satisfy, then he can be the governor. So let's see what are the qualifications given in the constitution. Qualifications. First, same, he should be 35 years of age. First, he should be citizen, very much understood. Citizen by any means, he can be the citizen by birth, he can be citizen by naturalization, registration, whatever means is there, he can be the citizen, and then he can be the governor. Now here I will raise a question. For example, after 2019, with respect to the illegal migrants who had entered India belonging to different religious groups, they would be given the citizenship. Can they be eligible for the governor's role? 100% they can be eligible for the governor's role. So it doesn't matter. Like in USA, there is the difference with respect to the appointment of the president. For them, he should be born in the USA, but with respect to India, it does not matter. You should be the president, you should be the citizen, and you should be the age, you should have completed their 35 years of age. It is what constitution has given. And after this, there are two additional conventions which are followed. Additional conventions are followed in appointing the governor. What are those additional conventions? First, for example, for the state of Punjab, or for the state of Tamil Nadu, they have to appoint a governor. That governor should be the non-resident of the Tamil Nadu. He should be non-resident of Tamil Nadu. So he should be a non-resident, then he would be appointed. This is adopted by the convention. It is not nowhere mentioned in the rules. And also, second, in appointing the governor, the chief minister of the state should always be, should always be concerned. Chief minister of the state should always be, concerned whether what is your opinion about it, should any particular person be appointed as the governor. So these are the additional qualifications which are adopted by our country, which are adopted it is adopted because of the convention. And also, as president is the first citizen of the state, first citizen of the country, the governor is the first citizen of state. So these are important facts about the qualification. They are very much relevant for your preparation in the exam. Now, who is appointing him? As we understood, it is the president who is appointing him. It is the president who is appointing him. But if we'll see recent trends, with respect to the qualification, with respect to the appointment, as it was very much specified, the president should be non-resident by the convention which we had adopted. In the recent trends, we are seeing that these two are almost ignored. For example, when they decided to choose the governor of the Tamil Nadu, the chief minister of the Tamil Nadu, he came to know about him through the social media, through the media, that particular person is going to be the governor of the Tamil Nadu. So these two qualifications are often, misused. These are often, they are not often adopted. So now let's see what is the tenure of the governor. What is the tenure of the governor? About the tenure, the constitution says it is the pleasure of the president. So this is the most controversial part about the governor. For the governor to be the governor, what would be the tenure? It is pleasure of the president, and indirectly it is the pleasure of the council of ministers and the PM. So it is the pleasure of the president. There is no fixed tenure for him. If governor does not obey the president or does not obey the central political party, then he may be changed. His position may be changed, or he may be forced to retire, or he may be his position would be dissolved. So he highly depends upon the pleasure of the president, that is the pleasure of the council of ministers. So because of this, as there is very much volatility with respect to his job, with respect to his tenure, so he always behaves as an agent of the center. He always behaves as an agent of the center, and he always behaves as an employee of the center. He will always behave as an employee of the center. But what the governor's post should ideally have been, it should have been the connecting link between the center and the state. Ideally, what was the need of the governor? The need of the governor was to look at the states. If they will anywhere go against the constitution, the governor would be there. Governor will calm them down and tell them, no, you cannot exceed that. And a governor will help them in the legislation, because at the time of the independence, the situation was totally different. Our legislatives, they were not that eminent personalities. They had not that much good qualification, and it was very much evident that now the legislatives who are going to be elected, who are going to get elected, they would be they would have the uneducated background, and for that they may make laws which may not be friendly with the people. So to have a check on them, to help in the best governance, the governor's post was there. And also see if they will deviate from the center, it would be there, because at that time the trust on the state was not, even though we had adopted it from the Government of India's Act 1935. At that time the situation was different. There was no trust between the crown and the states, the provincial governments. So definitely the need of the governor was there, so that it will keep check on the provincial governments. But once the independence we got the independence, but still there were concerns that many states, they would had wanted to secede out from the India. So at that time there was definitely the need to check them. So these were the reasons why governor should have been there, and he was the connecting link. But because of his volatility with respect to his post, there is no his post is not that permanent. His term is not established by the constitution. Because of that, he always behaves as a as a agent of the of the center, and he will always behave as the agent of the center, and will walk in way the center wants him to walk, will act in a way in which the center wants him to act. And because of this, because of his tenure, there are huge criticism, and criticism against the governor. So with respect to tenure, it is the pleasure of the president, and usually it is 5 years. Usually the term of the governor is 5 years. In this time period he may be shifted also if the pleasure is not there, and he may be dissolved. Now let's see what does the article 167 say. How does the council of ministers and the governor, they cooperate with each other? Let us see what does article 167 say. Article 163 of the Constitution. What does it say? It says there shall be a council of ministers with the chief minister at the head. So same as what is for the central council of ministers, with chief minister at head, to aid and advise the governor in the exercise of his function. What would be the function of the council of minister and chief ministers? Function would be to aid and advise in the exercise of his function, Is it mandatory? Is it binding? Is this aid and advice binding on the governor? 100% it is binding on the governor, but there is certain discretion also given to the governor, except in so far as he is by an order the constitution required to exercise his functions, or any of them in his discretion. If he has to act on his discretion under the constitution, he has to act on his discretion under the constitution, then there he will act on his discretion. So the advice is binding except he has to act on discretion. And what is this discretion? Is it defined by the constitution? No. That is the only fault, that it is not defined. This discretion, it is not defined by the constitution. Constitution does not define what is the discretion of the governor, but constitution says if there is a dispute with respect to the discretion of the governor between this council of ministers and the governor, then at that place it is the governor's word which will prevail. At that place governor's word will prevail. So most of the times whenever there is dispute, it is because of this the governor's word will prevail. So definitely the discretion is not defined, but the word of the governor, it will prevail. Because of this, there are various criticisms against the governor. Now let's try to understand what are various criticisms against the governor. Let's try to discuss them one by one. First criticism is misuse of power in appointing chief minister. So how we can criticize the governor in this situation? We discussed that, we established this fact that the governor, he is appointed by whom? He is appointed by the president. His tenure is on the pleasure of the president. So this pleasure of the president is the pleasure of the council of ministers, and the council of ministers at the center and the PM, it is the political party who is in the majority there. So definitely if the governor has to be in the power, he has to serve according to this by the constitution. He does not need to serve them, but to secure his job he has to serve them. So what he will do, he will misuse his power with respect to the appointment of CM, especially when there is an hung assembly. For example, there is a hung assembly. There are political parties. For example, we can take the example of Karnataka and Goa, where there were political parties, different alliances between BJP and some other political party and Congress, and some other political party. Similarly here, let's assume BJP and some other political party, and Congress some other political party. So there was no definite there was no definite majority enjoyed by any political party. So here the government will be piloted on the basis of what? On the basis of coalition. In this case, the BJP, in the Karnataka's case, there was one thing: the BJP, they had the majority of the seats, but not majority in such a way that they can form the government. Similarly, in the Goa's case, the Congress has the majority of the seats. So what happened in the Goa's case? The BJP and the other ally, they went to the governor, sir, we want to form the government. And similarly, Congress and other ally, they went to governor, sir, we want to form the government. So the governor, he favored the BJP allies that you form the government, even though they did not enjoy the majority. But here the Congress went to the governor that we want to form the government, but he did not allow them. He said that BJP is the major political party, let them form the government. So in a way, in nutshell, these are examples. In this way, what the governor is doing, he is misusing his discretionary power, where he could choose, where he, even though it is discretionary, but he has to choose, with respect to the lines, with respect to the morality of the constitution, but he is not doing it. So he is in a way favoring the political party at the center. The political party who is governing at the center, he is favoring them. It is not only in the case of the BJP right now. When there was Congress was enjoying the majority at the center during their tenure, the situation was almost same. Second, in testing the majority, for example, after the elections, after the elections are over, there is no clear cut major political party. What it will do, it will be governor will be biased towards the political party. It will give them extra time to test their majority. First, it will invite, for example, the BJP government to form the government, even if they did not enjoy the majority there, and it will give them extra time so that they can they can use their soft power in convincing different MPs to join them so that they can form the government. So they will give them extra time. So in this way, the power of governor in testing the majority is also one of the criticism, that he favors the central political party. And similarly, third, in dismissing of chief minister, we have the famous SR Bommai case, where in the Karnataka, where different MLAs wrote to the governor that he is involved. We are not favoring the SR Bommai now. Please, dismiss him as a chief minister. So the governor, what he did not consulted he did not did any research with those letters whether they are true or false. So what he did, he directly dismissed the SR Bommai as who was the chief minister. So in dismissing the chief ministers, this power is being misused by the governor. Similarly, in dissolving the legislative assembly. In dissolving the legislative assembly in 2015, we have the alliance in Jammu and Kashmir between PDP and the BJP, and in 2018 BJP withdrew from the alliance. And then it was the PDP, NC, and Indian National Congress. They decided to come together and form the government. They wrote to the governor, but governor did not respond, and he dissolved the assembly there. So it is believed that it is one of the power which the governor misuses. Here also the governor misuses his power. And similarly, his role with respect to the recommending president's rule, it is shown that he misuses his power there. And also in reserving bills for the president's consideration, there also the power of the president, it is said that he misuses this power, recommending the bills for the president's consideration. Right now this case is under the judicial review. Let's see what will happen. But now here, let us see what happens to the bills when they are passed by the Lok Sabha, legislative assembly and legislative council. If any state have, what will happen to the bills? What are the various options available to the governor? Let's try to discuss those options. First, once the bill is passed by the legislative assembly or the legislative council, the governor may give assent, may give assent. Maybe in UP there the governor would be from there is no discussion over it, so they will directly give the assent. Or second, withhold assent. He may withhold assent. Third, you know sent back for the reconsideration, for reconsideration. And fourth option available to him is reserve appeal for the consideration of the reserve appeal for the consideration of the president. So these are the options available to the governor with respect to the bills when they are passed by the legislative assembly or the legislative council. So here what used to happen, when the governor in the opposite political party, for example in Tamil Nadu or some other state, they will withhold assent or they will not sign it. They will not even send it back for the reconsideration. So for with this it was taking a lot of time in in the legislative business in framing the bills. So finally the Supreme Court intervened and Supreme Court said to the governor, why are you holding them so long? What is the reason for that? You cannot hold them for so long. Just cite out the reasons and send it back. Once you are holding it, send it back. And cite out the reasons what you are not comfortable with. And if they accept it, well and good. If they will not accept it, then sign it. So this is with respect to the withholding. And still these options were taken away by the Supreme Court from the governor, but still they have the option to reserve it for the consideration of the president. It's on this there is the this case is pending in the Supreme Court, and let's see what Supreme Court will say with respect to that. Still it is believed that the governor should act very in a way that if there is anything which is violating the constitution, there they should act, or which is violating if the state government is going rogue in a way, there this constitution, there the governor should come in and governor should act like that. Otherwise there should be a smooth business in the legislative front. So this is what the Supreme Court clarified. So here what are the options available to him? Either he can give the assent, he can withhold the assent, but not for longer time, as soon as possible. Then he has to send it back, or send back for the reconsideration. It is not an option. It is same as withholding the assent, and or for send it for the president's, send it for the consideration of the president. So after this, there are various tussles between the governors and the state council of ministers. For example, we discussed it with respect to the summoning the assembly between the Punjab government and their governor. They were not governor was not summoning the assembly. Why? Because there were few insult remarks made by the Punjab CM over the scheme which they had brought in, where 200 teachers were told to go to the Singapore, where they will learn the education system in the Singapore, and in this way they will implement the same system in Punjab, in India. So the question was asked by the governor to the CM, on what basis you had chosen those 200. The CM replied that on what basis you were chosen to be the governor. On this there was a tussle, and the governor was not agreeing to summon the assembly, and the matter went to the court, and court made it very much clear that in such situations it is mandatory. The advice of the council of ministers is mandatory on you. It is not something discretion. You cannot say that it is not it is your discretionary power. It is very much mandatory on you. Now here we see that there is often the conflict between the governor and the council of ministers with respect to various issues, whether it would be related to appointment of various officials, whether it would be related to the various bills, how the governor, if it is in the opposition political party in a state where that is governor in opposite political party, how he intervenes. But the question may come to your mind, what is the need of the governor in the present? What is the need of the governor. Why not we abolish this? Why not we abolish this office? We have the federal structure. The governor, at the end, what he is doing, he is in a way nullifying the federal structure of the country, and which is again the basic structure principle. So why not we abolish it? What is the reason of having it? So to understand that, first we will have to understand why we adopted it. As I told you, it was adopted from the Government of India Act 1935, and governor was provided in the provincial legislative assembly, and main focus was that to keep check on the provincial legislative assembly, so that he will be the agent of the governor will be agent of the queen or the king, or the crown prince. He will be the agent of the crown. So in this way they have to keep the check on them, whether they will go, whether the governor will keep check on them, whether they will go wrong or not. In the constituent assembly there was discussion over governor, whether we should have it or not, and many state that the governor should not be there, because why governor was adopted? Because there was mistrust between the Indian states and the crown. Here we had got the independence. So what is the reason to have the governor? And it was also highlighted by the KP Shah. KP Shah highlighted it that the time will come when the governor will misuse this power. He will act as an agent of the political party, where he will be very much biased towards them, and this is exactly what is happening. So what were the reasons why it was adopted? First, I told you that one of the reason was, certain amount of centralization of power is necessary. Centralization of power, a certain amount of centralization of power is necessary, because there is definitely the need of to keep the check on the states so that they cannot go wrong. So definitely certain amount of centralization is necessary. And second, it was highlighted that at that time, which we discussed, that the our MLAs, who were going to represent these legislative assemblies, the education level, it was very much backward, and they were going to make the laws. So to keep them on the check, the legislative assembly, the governor was the very much need of the time. But this time has changed right now. Right now, if we look at the state legislative assemblies, there are much more eminent persons who are in the state legislative assemblies who can make the laws. And also, there is no such tendencies which earlier used to have in different states, that they wanted to secede away from the Indian state. But now the situation is totally different. So why not we abolish it? Now with respect to this, there are three arguments with respect to the governor. One say, we cannot live without governor, because governor have various powers. First, when the president will impose the president's rule, who will govern the state at that time. Second, he is a vital link between the center and the state. Third, who will administer the tribal areas, because he has the power in administering the tribal areas under the 6th schedule and the 5th schedule. So he has the administration over the tribal areas. So definitely there is the need for the governor. Now with respect to some people say, no, we cannot live without the governor, the state cannot be without the governor. Some people say, why do we need him? Let's abolish this office, because he has created a much fuss in the country. Right now what is the situation between this between the center and the South Indian states? It is because of the governor. He is, and right now we have as governor is the document of the faith. We have this faith in the states. They will not secede away. He violates the federal structure, and he destabilizes the state government. Definitely there is no need for that. And for example, you need him for the sovereigning. For that, we can use the chief justice of the high court of that particular state. He will do the sovereigning and all that. He will, if there is emergency, he will act as the what the governor is acting during the emergency. So these are important issues. And with respect to the hung assemblies and all that, so with respect to that, why not we amend the constitution and bring in what were the alliances before the election? They will form the government. If first of the majority political party will form the government, then alliances will form the government, then second, third, who is the political party who is not enjoying the majority but has the maximum seats, they will form the government, and fourth, there would be the post-election alliances. So it can be made through the amendment. The government can be very much clear with respect to that. And this is the second sect of people who say that let's abolish this. Then there is a third sect who say that why do we, why are we going so much, why we are taking it so much seriously, and why we are discussing so much about his abolition and about his being there. We need governor, he's an important post, but we need to amend few, we need to bring in some reforms. So for that different commissions were created. First, the Sarkaria commission, and it has recommended few reforms which should bring in with respect to the post of the governor. First reform which they recommended, that he should be the eminent person, he should be the eminent person. Second, he should be the person outside of the state, from outside of the state. He should be detached figure and not to intimately connected with the local politics of the state. He should be the detached person and not that to intimate, and not that to intimately connected with the politics of the state. Also, he should not be that active, not that active in politics. He should not be that active in the politics. These are some recommendations given by the Sarkaria commission. And it should also be, it is desirable that a politician or active politician or any politician from the political party who is governing at the center, at the union, should not be appointed as the governor. And also permanent tenure should be given to him. Permanent tenure should be given to him. So these were few important things which were discussed, reforms which were discussed by the Sarkaria commission. And also after that, this Sarkaria commission, it was created in 1983 and it gave its report in 1988. And after the Sarkaria commission in 2007, Punchi commission was created, and they were told to give the reports with respect to the post of the governor. The Punchi commission said that why not follow the Sarkaria commission's reforms, and if you will ask me, I will give some. First, the Punchi commission also highlighted few important points, few important reforms. First, the governor should stay away from active politics. Second, the say of the chief minister should be very much in the appointment of the governor should be very much valued and respected. And also the doctrine of pleasure, which in the tenure part which we had discussed, that the governor is on the post because of the doctrine of the pleasure, because of the pleasure of the president. So this doctrine of pleasure should be removed. This doctrine of pleasure should not be there. So if if they are going to go through these changes, then it would be much helpful, and this post can be much fruitful for the well governance of the state. And also one of the recommendation was there, that there should be the recommendation on the governors. The state should recommend on the governor's impeachment. The state should recommend on the governor's impeachment. So these are the recommendations with respect to the governor's power, how he has the powers with respect to bills. We discussed that, how he can give the assent, or he can withhold it, or he can send it back for the presidential, he can send it back for the president's consideration. But in the withholding, he used to withhold it for the larger time period. The case went to the court, and court said that you cannot hold it for longer period, and you cannot create havoc in the state. Just cite out the reason why you are holding it, send it back, and then accept what the council of minister, what the bill they amend. Either they will accept your recommendation or not, then sign it. But with respect to the reserving bills for the presidential assent, it is still there. It is in the courts. With respect to it, the courts will decide what are the bills who are to be reserved for the president's assent. But here you need to understand, with respect to the president's reserving bills for the president's consideration, there is one bill on which he has to reserve it for. It is mandatory for him to reserve it for the president's for the president's consideration. And what is that bill? In case the government is bringing in the bill which is modifying, which is modifying or threatening the powers of the high court. If if the state government is bringing in the bill which is modifying or threatening the powers of the high court, then that bill the governor must have to reserve it for the president. He has to send it for the consideration of the president if such bill is brought by the state legislative assembly. Otherwise, there is definitely discretion, but this discretion cannot be misused. This discretion is only when they are going against the constitution. If the state is going very much rogue, they cannot go it on the personal choices. So with respect to that, it is very much made clear by the Supreme Court. And also after that, we discussed what was the necessity of the governor, what are the various statements, what are the various opinions with respect to the post of the governor, whether we should have it, whether we should not have it, and finally what are the we should reform this post, and what are the reforms recommended by the Sarkaria Commission, important reforms, we discussed that, and what were the reforms recommended by the Punchi Commission, we discussed that. Now with this, let's move to the another important topic, which is the pardoning power of the governor and the president. Let's move to that. Let's discuss that. After that, we will conclude our discussion. We will discuss the pardoning power of the president and the governor. So here, as I told you when we were discussing the president, that when we will discuss the pardoning powers of the governor, we will discuss it together so that it would be very much clear to you what is the difference between the two. Here, we will discuss the pardoning powers of the president and governor. So what are these powers? These are the judiciary powers enjoyed by the president and governor, and also we can say they are the mercy petitions. Under the judiciary powers, there are various mercy petition. So first we need to understand what is the need of it. The need is very much clear. For example, there is the courts make any judgment, they make it on the basis of records. What are the evidences? The judgment is made on the basis of evidences. The sentiments are something different. The judgment can be harsh sometimes, but for the better good, the judgment should have been much lenient. And this and this is not done by the courts. It would be done by the president or the governor through this power. This can be achieved by the president or the governor through this power. Or if the judgment is too harsh, there they can come in and enjoy this power. So let's see what are different mercy powers they have. Different mercy petitions we have. We have the petition of the pardon. We have the petition of what is this pardon? For example, if anybody is convicted for a jail term of 10 years, or or he is convicted for the death penalty, anybody. So this person will go to the president and ask him for the pardon, and once the president will pardon him, he will be as a newborn baby. So he will not go to jail. All his sins would be flushed out. So it will resolve. It will clean all his actions. So in this way, this is the pardoning power of the president. With respect to, for example, if anybody convicted for 10 years in jail, if any, for example, legislature, any MP, he is convicted of the 10 years in jail, he cannot contest the elections. How now? What he can do? He can what he can do? He can approach the president or the governor. He can tell them, please set him free, so that he can contest the elections. And if pardon is granted to him, he will achieve that. There would be no ban on him, as if he has never committed that crime. So this is the pardon. This is the power of the pardon. With respect to the this is the pardon of the power with respect to the president. He can pardon any sentence. He can pardon any sentence, whether life imprisonment, whether death sentence. He can pardon anything. But the governor, his pardoning powers are limited. He cannot pardon whom? He cannot pardon the death penalty. He cannot pardon the death penalty. So this is the first term. This is the first petition. Then what is the second petition? It is the commute. So let's see what this commute is. In this, the nature of the penalty is changed. For example, if it was if anybody was subjected to death penalty, it would be changed to the life imprisonment. So this commute power, it is available to both president and the governor. So in commute, the penalty would be reduced from death penalty to the life imprisonment. Then the third petition is respite. What is this petition? In this in the respite petition, the character and the nature of the punishment would be changed. For example, if anybody is convicted of 10 years in jail, with with regressive imprisonment, 10 years in jail with regressive imprisonment, it can be changed. This under the respite petition, it can be changed to 5 years with simple imprisonment. 5 years with simple imprisonment. So nature and the character of the punishment is changed from the regressive imprisonment to the simple imprisonment, and also from 10 years to the 5 years. It is achieved through the respite, and it is available to both governor and the president. So then the fourth is remission. Under remission, if you are given jail term for 14 years of the regressive imprisonment, it would be reduced to the 10 years of regressive imprisonment. The nature would be same, but the term would be reduced from 14 years to the 10 years regressive imprisonment. Nothing will happen to the nature. The term will be reduced. Then the fifth is reprieve. Under this, if there is any death penalty given to anyone, he will approach the governor or the president. What they will do, they will just stay quiet. They will halt on death execution. They will put halt on death execution. They will not say anything until this petition is with respect to under the governor and the president. He will not be hanged. So these are different petitions. These are different mercy petitions which are available to the governor and the president. So with this, here we understood that this except death penalty, which can be pardoned, the pardoning power of a death penalty, which is with respect to president, which the president has, except that everything is very much similar between the governor and the president. But also there are certain different facts which you need to know with respect to this topic. For example, here we will add president, here we will add the governor. So with respect to the pardoning powers of the president, president can pardon a death penalty, death sentence. Can governor pardon a death sentence? No, he cannot pardon it. Second, president's power extends over central laws, and governor's power extends over the state laws. Third, president's powers extend to the court martial as well, but the governor does not have such power. His power does not extend to that level. Why to the court martial? Because the president is the supreme head of the army. So because of that, he has this power with respect to the court martial. So this is the difference between the pardoning powers of the president and the governor. So here the question may come to your mind, why these powers are given to them? Because of the various reasons. For example, if court has pronounced you already guilty, and you want to correct a judgment which is deemed to be very much harsh. So you can do it, and to cover other things, it also covers other things. For example, we discussed it with respect to for example, there are wider sentiments involved in it. So what is this? For example, we know that the condition of various states in Punjab there are people who were against, who were in favor of who were in favor of the Khalistan. So suppose somebody was, they were, some officials were, somebody was caught, their leaders, they were caught by the police, and the case went to the court, and court decided, you know, to hang them. There was a death penalty against them. Now they will approach to the president. President will understand the situation. They will understand if they will allow them to, if they will pardon them. So what will it lead? It would be a good gesture. Not only this person will change his mind towards what he believed in, also the followers, the wider perspective of it, his followers will change, also change this mind, and they will get more connected with, the state. So in this way, in such in such situations, what president can do, they can pardon the guilty, pardon the person, so that it will have a wider impact, it will have the wider impact on the society. So this is why this power is given to them. This is why this power is given to them. And we discussed what are the difference between the pardoning powers of the president and and the vice president. So with this, we had completed today's discussion with respect to the state machinery. I hope everything is very much clear. I know I did not discuss the state legislative assembly in detail, because it is almost same. It will take unnecessary time for us to understand that it is not that important. One thing, it is not that important, and it is saying that what we discussed in last 4 classes, it would be discussing same thing but with respect to the state. So it is not, I don't think it is it is that wise to discuss it again. So just go through the notes. I will prepare the notes. There you will understand it more properly, and here the proper guidance is given to you, what is important for your preparation. As I always told you, whatever is important for your preparation, that we will cover. There in the syllabus there might be many things, but they are least important to you. For example, here, what is the need? You may ask me a question, sir, you had promised that you will cover everything. Why did not you discuss everything with respect to state machinery? But what is the need? It is not needed at all, because it is same as the legislative assembly. If as the Lok Sabha, if any question would be asked with respect to that, you should easily be able to answer that. What were the differences that we had discussed? Rest, it is almost same. So with this, I would like to conclude this discussion. I hope you would have liked the video. I hope you would share it with your friends, and I definitely hope you would subscribe the channel. Thank you for staying with me. Thank you very much, and have a nice day. And one more thing I would like to add, if you would had not watched my earlier 20 lectures, please go to the playlist. There they would be available, or if not there, at least check the comments. There I would comment, I would give you the link of the playlist. So with this, I would like to conclude it. Thank you for staying with me. Thank you very much, and have a nice day.